the special counsel Jack Smith seeking review from the U.S. Supreme Court on post-presidential immunity. Now, we have a little bit of experience when it comes to the Supreme Court and presidential immunity. We'll talk about that in a second with my dad, Jay Sekulow, who was representing the president in those cases. But he skipped the Court of Appeals because he still wants to have this trial to start, you know when? March 4th, the day before Super Tuesday, because he's not playing politics with this at all, right? Saying that politics isn't involved, everybody looks in the calendar right there and knows what they were doing. But, Dad, this is unique because it does show he's got some concern, which is interesting, that about these issues because they did come up by Congress. Congress impeached the president twice. Both times he was found not guilty by the Senate, who actually is like the judges. And the second time he was no longer the president. So this kind of ties into that one as well.
The special counsel's office has filed a petition for writ of certiorari. That's a request for review before judgment because it's pending at the U.S. Court of Appeals for the District of Columbia right now. So what Jack Smith wants to do, because of timing, is to expedite the matter and skip the intermediate level of review because ultimately the view is that the Supreme Court's going to have to decide this. It's a very interesting legal issue, and that is, can the President of the United States, when he's no longer in office, be held criminally liable for activities that took place while he was president? Now, we had, as Jordan said, we've had some experience in this because I argued for the president a limited temporary immunity while he was president. So you're going to see the Supreme Court argument. The question was by Clarence Thomas. The argument took place right here in this studio because it was during COVID, so we were connected to the court via phone lines. Take a look.
Interested in whether or not you can point us to some express language either at the founding or during the ratification process that provides for this immunity.
Well, there's a couple. There was a colloquy between ultimately Vice President Adams and Senator Ellsworth where they talked about process against the president, and they took the position that any process against the president would be constitutionally problematic. Thomas Jefferson, of course, wrote in the letters he had regarding subpoenas that were issued in the Byrd trial that allowing local magistrates to banter about a sitting president from north to south and east to west would interfere with the president's responsibilities. And as this court just in the previous argument just stated, the burdensome nature of this is categorical. It's not, you can't just look at the one subpoena. It is the potential for 2,300 DAs, or just 1% of them, 23 DAs issuing process against the president. But the concern over interference from our founding with the president's responsibilities was discussed, and that's why in the Constitution there's process to deal with it.
We have the expertise on this more so than anybody in the United States. So the real issue here is what Jack Smith is trying to do is make sure this case goes to trial in March. That's what he wants. He wants the trial before the election, which I think looks like election interference, and normally these cases would never go to trial this quickly. No. Criminal case in the District of Columbia on this magnitude would not be tried, a year after indictment.
The state cases are trying to do it without even the charges. They're trying to say an elected Secretary of State can just decide on their own review that they can disqualify him. Now, they didn't trust that they could totally do that, by the way, on their own because they said, we probably should take it to court, see what a state court says on it. But if the state court says I can, then I can do it. Jack Smith's track then is I need to make sure I get this in before people start voting because, or even maybe midway through. So he's on some primary ballots, but maybe won't be on enough.
They want this expedited appeal for one reason and one reason only, to make sure that they can try this case before the general election. Take that, combine it with the, 15 cases we have now where they're trying to get the former president off the ballot, and for most recent now being in Wyoming. We're intervening on behalf of the Wyoming Republican Party. 15 issues right now on the state level. The Supreme Court now weighing in. Folks, this is huge for your right to vote.